So what we're going to do is, as we go through this, I'm going to ask everyone just to kind of keep that out. I'm going to make references to that rule. My understanding is we've got some students here, we obviously have some veteran practitioners, and so I'm going to have to kind of speak to both sides. I'm going to have to talk about Rule 16 historically and kind of the basics of it for those of you who are new to this area, and then also for all practitioners and students as well, who are obviously going to be starting to practice criminal law. We're going to see what the new rule will be as of July 1st, 2010. So very quickly, I also should say that this presentation is usually geared for time between 60 and 90 minutes. So I am going to talk very fast. I'm going to go through slides very quickly, and so please just bear with me. There's a lot of stuff to go over, and we're going to cover both ends of the spectrum. So for those of you who have not engaged in criminal defense before, we usually start out with our indictment. Okay, and basically here's the burglary example, and it just recites the exact language from the statute, which the person's charged. Now this right here, what this is, and this is why I put this next in the margin. Usually I give this presentation with representatives of the Ohio Prosecuting Attorneys Association, and I do have to state at the onset of this, they have spent countless hours with us. We have met now for 3 years. It's been going on sometimes on a weekly basis at the Columbus Athletic Center, teleconferences, so on. And so I do have to thank them. I think everyone does need to acknowledge that they've met us halfway on this. They get tired of me every time I give this presentation. Usually what I do is if something that we're talking about comes up. Of course, the Open Discovery Advocate Angel is to the left of our material, and they keep saying to me, Ian, would you please stop putting these double symbols above all of our stuff? So that is really what that is. But the argument, the position has been, and when we started this a couple of years ago, the first time we all sat down at the same table, and there really were about 6 representatives of the Prosecutors Association, 6 representatives from the defense bar, and we sat down and we said, what are our issues here? And it's amazing to see where we've come from and where we are, because the positions were, prosecutors said, look, we need to protect our witnesses and victims. We are already in compliance with Rule 16, and that's correct. And if we were to change anything, we lose our discretion, and we are elected officials. So I think they're very valid positions. The first recognition was that we all kind of agreed on those points. The defense, we have always argued that we've been unable to prepare adequately. We always hear the term trial by ambush, and that is oftentimes what the case is. We're not knowing, for those of you who have not been in a criminal trial, we don't know what our witnesses are going to say oftentimes until after they have testified, when we have to approach the court and say, can we review their written statements that they gave previously. If we find any material inconsistencies or anything helpful to our clients, we make the pitch to the judge, and we can then use that statement to impeach at that point. It's a tough way to go forward in trial. The higher expenses, so often we've had to employ private investigators and really recreate the case when we know the prosecution has everything that we're looking for right there in hand. So the expenses that are incurred are increased not only for the privately retained counsel and those defendants, but also the expenses that are incurred in the public defender system to indigent defendants. And Tim Young, our public defender here in Ohio, really put it out nicely as he was able to put down the numbers and say, this is why Open Discovery will save Ohio money. The defendant's right to a fair trial, again, as long as we are using the terms ambush, and as long as we're in gamesmanship, and both sides going back and forth, there's always going to be arguments that there are fair trial violations. How well can we help our clients when we don't know all of the evidence? So we've got Sixth Amendment implications all the time. And the biggest problem was that Rule 16, even though we agree that there may have been compliance with Rule 16, we've got 88 counties across Ohio, and every county practices and applies Rule 16 differently. So those were kind of the 2 sides of it. The old Rule 16, which the lawyers in here are very well versed in, you all know that this went into effect in Ohio July 1st of 1973. Since that time, since 1973, this debate for open discovery has been going back and forth. Yes, there are photos, there's fingerprints, and then as you see here, there's a whole list of representatives. Representative of the clerk of courts, representative of the sheriff's department, probation, police department. That may sometimes be the best that we get. And that's a tough way to get ready for trial. We're going to hear obviously about civil discovery here in a minute, and the one thing that people are always outraged by is that when it's like you get into a car accident, you can get the statements of witnesses, and the defendants and so forth, but you can't get into a criminal case when the life is dependent upon it. So it was this type of example that we really had to address. And again, as you see, I highlighted here, this is what we may sometimes get for trial. So what we're caused to do is file motions to compel. It's a lot of unnecessary litigation. And we have to make the arguments that it's instrumental in the case and so on and so forth. Again, it's expensive for the private clients and really taxing on public resource for the state if you've got to go through all of this, which is really, frankly, unnecessary. The bill of particulars is the second component of information that we're supposed to get. That is supposed to give you the specificity of the charges. And again, what you see here, and everything's obviously been redacted, but all it does is again recite the elements of the offense: unlawfully did by force, stealth, deception, trespass, unoccupied structure, etc. That's how you're supposed to be prepared to go to trial. So, moving on, 88 counties, 41 of them